It's an honor to present the chair of the panel, Professor Jennifer Trahan. She is the clinical professor at the Center for Global Affairs at the New York University. She is director of their concentration in international law and human rights. She has served as a consul and of-consul to the International Justice Program of Human Rights Watch, Iraq prosecutions consultant to the International Center for Transitional Justice, and work on cases before the Special Court of Sierra Leone and the International Criminal Tribunal for Rwanda. She has published extensively, and she also has served as one of the United States representatives to the Use of Force Committee to the International Law Association. She is the chair of the American branch of International Law Association International Criminal Court Committee, and she has published 2 digests on the case law of the ad hoc tribunals. Currently, she is working on a book called Legal Limits to the Veto in the Face of the Atrocity Crimes under Cambridge, and we hope that we receive that book soon. Thank you very much, Professor Trahan. The floor is yours.
Thank you so much. Thank you for that introduction. It's a great pleasure to be here, and welcome to our very distinguished panelists. So our topic is the endeavors of the international community in achieving accountability. And we're going to start by looking at the role of the UN Security Council. And of course, you all know that in 1993 and 1994, respectively, it created the Yugoslav and Rwanda tribunals. And of course, I think it's appropriate to reflect that these tribunals were only created after the UN's very slow reaction to the wars in the former Yugoslavia and the unfolding atrocity crimes, and its role in designating safe havens, including the one at Srebrenica, which of course was not safe in any way and resulted in mass catastrophe. The ICTR was created, of course, after the complete lack of responsiveness by the UN system to the unfolding genocide in Rwanda. And these maybe are a reminder that accountability is always plan B. Plan A should always be preventing the crimes in the first place. And maybe there needs to be renewed focus on this because it does not seem to be at the top of the agenda despite all the work that went into the creation of the responsibility to protect doctrine. We may well ask where it has been, particularly regarding Syria, where it is regarding Yemen, and many other situations. But I'm delighted we have the prosecutor of the formerly ICDY prosecutor, now prosecutor of the residual mechanism, to discuss the role of the Security Council and the mechanism. And of course, the Security Council has also created the Special Tribunal for Lebanon. I know that's the topic of a different panel, so I think we won't discuss it here, but of course, so the Security Council can also create a hybrid tribunal. The Security Council has additionally referred 2 situations to the International Criminal Court. It has never done any follow-up to its referrals, and it purported to exclude funding with those referrals. And I say purported because when I read the UN Charter, it says the GA makes funding decisions. But we can ponder why not other situations and what's the potential for the Security Council really to do meaningful contributions in this difficult political landscape. We'll then switch to talking about the General Assembly, and of course, because of the veto at the Security Council of the referral of the situation in Syria to the International Criminal Court, the General Assembly took on the task of creating an investigative mechanism known as the IIIM. Unfortunately, Catherine Machiul will not be able to be here, but I'm delighted we have Stephen Rapp, who's agreed to talk about the IIIM with us. And of course, we have two new mechanisms as well, UNITAD collecting ISIL crime evidence in Iraq, and the IIMM for Myanmar. And I think these raise profound questions for those of us interested in this field. What do we make of the creation of investigative mechanisms instead of tribunals? And we'll maybe explore this. And I don't mean to minimize the important work of investigative mechanisms, but again, they're hopefully, they're the first stop to what we would like to see is more fulsome accountability. Delighted as well that we have Direk Ladi. He has worked firsthand on the ILC creating the Crimes Against Humanity Convention we've been hearing about, and will also reflect on the General Assembly's role. And I know the ECCC is also the topic of another panel, so we won't really cover it, but I do believe the negotiations to create it never went to the Security Council. So the General Assembly can set in motion the mechanism to create a tribunal. So the ECCC in many ways is not a model of a hybrid that we would follow, but in that its creation was triggered without the Security Council, I think is an interesting development. So this is perhaps a difficult geopolitical time for the field of international justice, and we may need to be looking at more creative and resilient ways to achieve it and workarounds, unfortunately, based on kind of the realities of some of what is possible, starting with the Security Council and sometimes limited possibilities. But I'm going to start with Serge, and of course, I think known to probably everyone in the room, of course, was the ICTY prosecutor for many years, is now the prosecutor of the residual for both Yugoslavia and Rwanda, was the deputy ICC prosecutor, and was in charge of the Hariri investigation that fed into the work of the Special Tribunal for Lebanon. So, Serge, start us off with kind of the political climate that allowed the creation of the Yugoslav and the Rwanda tribunals, and how was the context that, that permitted these tribunals to be created?
Thank you very much, Jennifer. Good afternoon, everyone. Indeed, as it was said several times this morning and by you this afternoon, we are all facing difficult times, those who are strong believers in international justice and those who know that we need more and not less justice in those different conflicts around the world. It's always a good exercise to see what was done in the past, to reflect what worked and what could have been differently. And of course, I remember when I started at the ICC, the ICTY was the old model, and now so many years later, there is somehow more interest and attention in relation to what worked well and what could have done better, and what are perhaps lessons learned for new judicial mechanism and accountability mechanism today. So if you look back at the 90s, I mean, all of us, we say it in all our presentations that nothing happened between 45 and the 90s, the Cold War, and I was reading one of the old articles of our friend Passioni, who mentioned that there had been in this period 250 conflicts and between 70 and 170 million of victims, and nothing happened in terms of accountability. Just to say that we always all agree that despite all the problems we are having today, a lot has been achieved in the last 25 years. So if we look back, and of course we have David Scheffer here, who was at the forefront when ICTY was created, and it was clear that after the Commission of Experts had been put in place, the international community was looking, especially the Security Council, for action, what to do in relation to the conflict in the former Yugoslavia. I think it was one of the first conflicts where you had a lot of images in the media, and we see even more today how important the media and social media is in this regard. At that time, very much the Clinton administration who took the lead, times where, which was also very visible at the ICTY, with a lot of prosecutors from the US coming and still being there. There was a lot of political pressure on the members of the Security Council because, as I said, it was well known that the crimes were committed. There was no really appetite to send troops in. So the Security Council was looking for alternative options, and well, one option was setting up a tribunal. The US was very pushy. UK and France were fine with it. Russia, China, not super enthusiastic, but they finally accepted it. And you know, the day before yesterday, I was at a book launch in The Hague by one of the former investigators, Vladimir, who was there in the very early days when the first arrest took place. And he showed a video with Madeleine Albright, where she was interviewed not a few years ago about the creation in the Security Council about ICTY. And she said what I've heard from her as well when she spoke at another conference in The Hague, saying, look, we took this decision in the Security Council for the first time. We were not sure that really something would be happening afterwards. Once we saw that there was a tribunal in The Hague and judges were appointed and the prosecutor was coming in, we were not thinking that really people would be arrested. And when she spoke in The Hague at a conference a number of years ago, she really said that, well, no one would have imagined that one day all fugitives, Karadzic, Mladic included, would have been arrested and prosecuted. So definitely an important first step, but as we said, it was the first one, and then, you know, I guess I wait for the next question. Of course, I could develop now into all the other initiatives which have been taken.
So both ICTY and ICTR had Chapter 7 powers. You still had, I know, early on difficulties in cooperation. But ultimately were very successful. Sorry, okay, I will say that again. So the ICTY and ICTR had Chapter 7 powers, and that is obviously a significant aid. But I know in the early work of the ICTY, you had a difficulty getting fugitives to The Hague. Can you discuss how this worked and kind of sanctions that were imposed for non-cooperation?
Well, we have always considered it as being a big advantage to have been put in place based on Chapter 7, which in theory allows the use of force to have the mandate implemented. And it is an obligation for all member states of the United Nations to cooperate with the two tribunals. So it's definitely one of the big differences between all the other initiatives, hybrid mechanism and other initiatives. Now, what has been the impact in reality? I mean, there have been a number of presidential statements, there have been a number of resolutions, but not really sanctions imposed for non-cooperation. But there have been a number of resolutions in the past where the Security Council called on member states to consider imposing measures against individuals or organizations who would be involved in harboring the fugitives. So there have been a number of decisions in this regard. If the ICTY has been relatively successful, it's definitely one part is the obligation to cooperate, but at the end of the day, it has been much more specific incentives, if not to say pressure, which really made the difference. Many of you remember that in relation to the arrest and the transfer of Milosevic, it was very much after the US made very, very strong pressure to say, you know, we will only finance certain measures once he has been transferred. And in relation to Karadzic and Mladic, I remember very well when I arrived at the ICTY, many in the diplomatic community were not very positive and optimistic about the chance to have those arrested prior to the closure of the tribunal. And there it's definitely the European Union with the conditionality policy, which has played a very, very important role, which always leads us to this one conclusion that international justice can only really work well and prevail if there is a clear political will of support and if there is political will to see it being successful.
So now you're in the mechanism phase. Do you want to tell us a little bit? Sorry, I'll just leave it on. So now you're in the residual mechanism phase. Do you want to tell us a little bit about the work, the challenges that you have now, and the Security Council's role?
Well, it's great because I went from 500 staff members to 100, so the life is much more easy in terms of organization and management. But more seriously, the system is still very much the same. We are still every 6 months reporting to the Security Council, but the issue of non-cooperation remains very, very similar. You know, we think having identified the location where one of our remaining fugitives is, in South Africa. We are for 1.5 years asking South Africa to cooperate, to arrest. We have mentioned it on 2 occasions already in Security Council meetings, but little is happening in this regard. But as I said, you know, the residual mechanism will continue reducing staff based on the last cases which are still ongoing with Mladic appeal and Stanisic Sematovic trial. But what is quite interesting is that in fact we have today the highest number of requests ever coming from Serbia, Croatia and Bosnia, which is quite interesting that after the closure of the ICTY, the number of requests we are receiving, more than 300 a year, in relation to more than 200,000 pages of documents to be used in national proceedings is really quite remarkable, which also very, very much shows that as international prosecutors and international justice, you can only do one part of the job. And ICTY with 161 indictments, which we all know is very much compared to other international mechanisms, it is still very little if you think about the 3,500 investigations which are still ongoing at the national level. And so definitely where the mechanism has an important added value is really to continue helping national jurisdictions in doing their work. So the positive complementarity we have been obliged to put in place because of the completion strategy at the end of the day was a good thing.
So you were ICC deputy prosecutor when the Darfur situation was referred, and then there was also referral of the Libya situation, but for instance, Syria has not been referred, or Yemen, Myanmar, Sri Lanka. There are a fair number of situations we could think of that should have been referred. Why is this? Do you have any optimism that the Security Council is actually going to be able to act in the future and make referrals under Article 13b of the Rome Statute?
Well, I'm optimistic by nature, so I hope that one day countries will, you know, not act based on national interests, but based on what they think is the right thing to do to help humanity moving forward. But that's perhaps today a little bit of wishful thinking. I remember very well at the ICC when we got this very unexpected referral from the Security Council. And opinions were very different at that time, if it was really helping the ICC or not, because you mentioned it already, no budget was coming with it. Not really very, very strong support. And again, the impression at that time, while on one hand we were very pleased to see that there was a breakthrough having the Security Council with the permanent 5, especially 3 of them being supportive, was obviously an important achievement. But it was also quite obvious that it was a decision taken because all the rest had failed, right? I remember Colin Powell already had mentioned the genocide in Darfur. There was already a peacekeeping operation. There were already economic sanctions. There were also a lot of images about the conflict. So it was definitely an alternative to a military intervention to send the referral to the ICC. And overall, I think it was received very, very positively. But we all know the reality over the last many years since the arrest warrant came out against Bashir. And we all know how much he has been able to travel, and that the same countries who supported the referral later on did not do their job by having him arrested. Libya situation being obviously a little bit different political context, where military intervention came very, very quickly, almost at the same time with the referral, and where the ICC started the OTP very, very quickly. An investigation generating also some criticism in this regard. And then obviously in relation to Syria, Yemen, well, we all have watched the first time, second time, sixth time, I think 8 times that Security Council was trying to come up with a referral or with a specific decision, and this obviously did not work. So I don't see the Security Council in the very near future changing its incoherent policy which we are seeing today. And I mean, that's the topic for my colleague speakers, that it is obvious that the international community is looking for alternative ways of bringing perpetrators to justice by having accountability mechanism, investigative teams, Syria mechanism, and others, which are not full-fledged accountability mechanism in the sense of tribunals, but which are more than an investigation commission old style. But that's obviously a topic for my colleague.
We were chatting before the panel, and you mentioned one of the vetoes that was cast was the Security Council would have to commemorate one of the genocides, the genocide date of July 11 in Srebrenica, would have passed a resolution calling Srebrenica genocide. And of course, the ICTY was created by the Security Council, so, and the ICTY has adjudicated Srebrenica was a genocide. But that resolution could not be issued by the veto power. Do you want to comment on that? Or you said there are budget issues as well that have become difficult.
Well, I think we all agree that the Security Council is more a political body than a judicial one. But by having created the ad hoc tribunals, they laid the ground for those tribunals to come up with a very important jurisprudence, which I think has really helped international criminal justice moving forward. You know, we have had other events where we spoke about the important jurisprudence in relation to genocide, command responsibility, joint criminal enterprise, etc. So in this sense, the Security Council indirectly has contributed to have all this jurisprudence. Of course, it was very disappointing to see that when there was the commemoration of the 20th anniversary of the Srebrenica genocide, and the Security Council wanted to have a resolution recognizing the genocide, that a veto was used, where the tribunals which have been put in place by the same Security Council have decided again and again, in first instance and in appeals, that the crimes committed there were genocide, including the ICC. So it is, of course, disappointing to see that the political body, which is the Security Council, was not really able to confirm what had been done in this regard.
You mentioned as well the completion strategy, and that this was mandated, actually had the benefit of kind of forcing the ICTY to reflect on, you know, how it could further prosecutions in the region. Could you talk a little bit more about the importance of this and kind of the numbers and as expand on that, perhaps?
Again, historically, in relation to the mandate, ICTY has primacy, like I say, primacy over national jurisdiction. So in the early years, definitely much less interaction with national jurisdiction, as complementarity as such was not really playing the same role. When in 2004 the Security Council decided, well, you know, we want to see an end of the work of the ICTY, we don't want you to start new investigations, we want you to only keep the few major cases and you have to transfer the other ones. This was really the opportunity for the tribunal also to be very, very much involved in helping countries in the former Yugoslavia to develop their legislation, to be able to receive those cases, to transfer an important number of cases. When I took office in 2008, one of the first decisions we took was to integrate into our office liaison prosecutors from Serbia, Croatia, and Bosnia, which still today are working in our offices, showing that working in both directions has been extremely important. And you know, with a database of 9 million pages of documents, as I said earlier, we are transferring a huge amount of documents every month. So the completion strategy in this sense has been a very, very positive development. And I think we discussed this last time when we were here, when we were speaking about ICC topics, where we also said, well, what the ICC will need one day are completion strategies for each situation where the ICC is working today, because situations which have been opened 18 years ago, well, what's happening? They cannot be open forever. In this sense, where primacy was the initial starting point, today I would say of all the accountability mechanism we have, is the ICTY, ICTR, the most complementarity driven, if I may say.
Great. Thank you for that. So I guess as you've gathered, I'm going to stick to one panelist at a time and do a series of questions. And we will have actually, because we've been allotted 2 hours and we've lost our fourth panelist, so we will have a lengthy Q&A period at the end. So please do think of your questions. So thank you so much for that, Serge. So Stephen, delighted to see you again since it's been so long.
Good to be here.
Last week.
Thank you, Klaus, Vivian, and everyone for bringing us back together.
Probably almost everyone knows that Stephen has served as the U.S. Ambassador at Large for War Crimes Issues and the head of the Office of Global Criminal Justice within the State Department. Previous to that, he was the prosecutor for the Sierra Leone Special Court, leading the Charles Taylor case, and before that was at the ICTR leading the media prosecution. So, Catherine isn't here, so you're going to get IIIM questions, but also mechanism questions more generally, because as I mentioned in my opening remarks, we have had maybe a shift in this field. So I guess that's one of my questions. Is this a shift? Is this a blip? Is this where our field is now going? The field seemed to create tribunals, and now recently we have 3 investigative mechanisms. The IIIM collecting crime evidence in Syria, where creation of a tribunal seemed very difficult, and we can maybe talk about some of the possibilities. Another one is UNITAD, solely collecting evidence of ISIL crimes in Iraq, and that is Security Council created. The IIIM is General Assembly created, and the Myanmar mechanism is created by the Human Rights Council. So 3 mechanisms doing different things, but compiling evidence. First, what do you make of this development? Is this our future of our field now? We have mechanisms to compile evidence and not tribunals. What do we make of this?
Well, I think we're going to get to justice. That's the essential point. And collecting the evidence, particularly at the time the crimes are being committed, and doing it in a professional way, and analyzing it, and building cases of individual criminal responsibility is of great advantage if the case eventually goes to the ICC or if it goes to the national level. And I know there was some indication, I mean, implied in your question, you know, obviously we'd be better off with tribunals. We think we'd be better off if the ICC had gotten the Syria case in 2014 instead of having 13 votes in the Security Council and 2 no. But really, since 2011, it's been extremely difficult to move on current justice issues in a whole variety of situations because you don't have ICC jurisdiction, or at least very direct ICC jurisdiction, but based upon the state party, and the Security Council is fundamentally blocked. When I became ambassador at large for war crimes issues, we later changed it to global criminal justice and was in that job for 6 years. I always expected that as I, did my 1.5 million miles or 2.5 million kilometers of travel, I'd be going to The Hague at least every month, and I continue to do that. But I ended up by 2011 adding Geneva regularly to that list, which of course people would ask, well, what's that have to do with you? Human rights law is soft law, it's state responsibility, it's not individual responsibility. But we ended up in a situation with a great many situations, which were frankly situations of atrocity crimes, of Rome Statute crimes, where it was impossible to get the kind of commission of inquiry that we had under Sharif Baziuni before the Yugoslavia Tribunal, that we had under the late Judge Cassesi for the Darfur referral. And so we'd go to the Human Rights Council, And the Human Rights Council, dealing with, international human rights law, would pass mandates, but they would often put in their mandates, determine whether the violations are crimes under international law, determine who is responsible or what units are responsible, if possible, make a list of suspects, potentially. So you're actually asking them to do something that really Geneva wasn't, in a sense, prepared to do, but it was the best alternative. And so we had commissions of inquiry for, in situations where the ICC, where the Security Council would have blocked it. Syria, we couldn't get anything on Syria. We can't even get the most minor sanctions on Syria. We had an investigative mechanism for a short while on chemical weapons, and the extension of it was vetoed by the Russians. North Korea, we'd have had a Chinese veto. Sri Lanka, we'd have had a Chinese veto. South Sudan, we wouldn't have got to 9 votes. I don't know if we would have had a veto there. Myanmar, a Chinese veto. Yemen, who knows? But certainly on something the U.S. and the U.K. didn't really want. Same, obviously, with Israel, Palestine, and the Gaza in 2014. And most recently, by the way, I don't know if people saw, but 3 weeks ago today, the Human Rights Council established a commission of inquiry for Venezuela. And intriguingly, where it requires, in the Security Council, you have to have 9 out of 15 affirmative votes, 3/5, and no veto. At the Human Rights Council, all you need to have is more yes votes than no votes. 19 votes there's 47 on the Human Rights Council. There were 19 yes, 6 no, 21 abstentions. There's now to be a commission of inquiry for Venezuela. So it is a place where you can get something going in the international system. But does it collect the evidence? Does it respond? I see my friend Christian Richer out there when he wants something from the Syria inquiry. Will they have the information that he needs? They'll have a lot of information on the horrible crimes. They've interviewed 6,000 victims. They'll talk about what kind of crimes they were, but will they have the connective issues? Will they have the documentation? Will they have the digital material? They'll have some of it, but not all of it. They don't have the capacity in Geneva to do that. And so the idea, when we got the Security Council blocked and unable to send it to the ICC, of picking up the game, using the General Assembly and creating a mechanism that could do what the Commission of Inquiry couldn't do and really build the files. Now, do keep in mind this IIM also took place after some other developments, because as of 2012, looking at the situation, countries like my own launched the Syrian Justice and Accountability Center, which then led to all sorts of support of civil society organizations that were prepared to gather the evidence. I'm, point of personal privilege, I'm chair of the CIJA board, which has collected 800,000 pages of documents, largely linkage evidence from inside Syria, working with people inside Syria. You've got groups like the Syrian Network for Human Rights, that's done fantastic things on the victims, can tell you the name of 128,000 people who have disappeared, either been arrested or disappeared and are believed to have been put into the detention facilities and maybe dead now, maybe alive, but they can tell you the names. You can go to the Syrian archive. They have 2 million videos, media archive. There are other groups that are doing that, and the IIM serves the role of being able to reach out to those groups, bring in that material, collate it, verify it, to some extent eliminate the sort of donor biases that people fear when you have sort of NGOs supported by individual governments, and build files. And I think it lays a very solid foundation for justice. Of course, it's not happening at the international level. It's hard to figure out how it would. With the Security Council blocked, people talk about a General Assembly, created tribunal, but it wouldn't have Chapter 7 powers. It wouldn't have a budget. Probably it would have to be voluntary contributions. It would be something that I think a number of states would have serious problems with. So it's hard to figure out, in the absence of a transition in Syria, where you'd have some hope of establishing a hybrid court in agreement with the international community, and that seems to be just completely beyond the realm of possibility given the situation there now. This is a way that we can establish justice. I come from the state of Iowa. In Iowa, people love to go to movie scenes, where movies were filmed. About 50 miles from our house, we have the Field of Dreams, and you remember the slogan of the Field of Dreams, if you build it, they will come. Well, if you build the cases, I really do think that justice will come. You've got to keep working, you've got to find allies, you've got to build the cases at the national level using universal jurisdiction or passive personality jurisdiction, and I think we're seeing that happening. I was intrigued. I know, I'm not sure I necessarily agreed with it, but I'm sure some of the people here were at a side event that was held during the ICC ASP last December on Syria accountability, and a lot of civil society organizations, and Catherine was there and others. And we had a European ambassador who spoke at one point, and he said, you know, we're probably further along today than if the ICC had taken this case in 2014. In terms of the number of cases and the activity and the development of documentation. I mean, keeping in mind the ICC has only 82 or 72 investigators. You know, it is interesting that, you know, we're seeing this kind of action. I think I'd much prefer that the ICC have jurisdiction so you could go after an Assad, you could go after top people, you'd have the right to do it. But in terms of the sort of case development and investigation and the sort of activity and action, I think there's a lot positive. Now, I'm just talking Syria. We obviously have, we can talk a little more about the Iraqi mechanism and its narrower mandate, Myanmar, and these situations where we don't have a mechanism, but we really do need information to build the foundation for eventual accountability.
But in some ways, I mean, do you have any fear that the international community will fallaciously think, oh, look, we've created this, you know, we've done our bit for accountability in Syria. And this, you know, not in any way to minimize, but it is not a holistic look at the top level perpetrators. The you know, chains of responsibility is more a feature of what, you know, what is more in the short term immediately possible. You mentioned SJAC, and Mohammed Abdallah would be the first to say, Syrians are very upset to think that a handful of European cases will be it. You know, you know, is it delusional to still try to insist on a tribunal in this instance? Because I think there are so many voices, maybe not in the room with us today, who would say, no, this is not what should become of our field.
Well, it shouldn't, you know, and we should find a way to build a tribunal. But and I've thought of, you know, creative approaches, pooled jurisdiction courts. I mean, you know, there are a variety of sort of angles on this. I mean, even recently the discussion of an IS tribunal where various countries would pool jurisdiction, et cetera. But that in that situation, even then you have the challenge of where that tribunal is going to be located and the cooperation of the state where the prisoners are being held and all of those complex issues. So it is difficult to make progress on the international approach right now. And I'd like to think that we would have a better alternative. I do keep in mind that one of the things that the tribunal, or that the IIM is doing, it's doing structural investigations. I mean, to some extent, like we would do at the ICTR, we'd be sitting there and saying, well, we need to deal with the military, we need to deal with the militia, we need to deal with the political leaders, the business leaders, the clergymen that incited, the media. And so we would look at things and at the various aspects of criminal responsibility, and we look at geographical sort of responsibility, and I think the IIM is doing that. So they're building towards something that would lay a very solid foundation for a tribunal. But at the same time that they're doing that and building the solid foundation, then they're working on individual dossiers, you know, as far as individuals that could be prosecuted today. And I think that what's positive is that those cases can go forward. I mean, I would. You know, on this whole question of the IIM and its role and where it's going to be in the future, I do think that this is a topic, if we're going to go to the national level where, you know, laws may need to be reformed in some states, there needs to be more cooperation across state lines to work cases, there needs to be, to some extent, a more strategic approach at the national level. And it varies. I mean, obviously, in Germany, you have universal jurisdiction if the national prosecutor, the federal prosecutor, finds German interests, German witnesses, et cetera. France, got the ability to investigate, say, torture, but they can't begin a case against any individual unless he's present in the country. Other countries generally put the greatest premium on going after the people that are in their country, and usually that as a result, we see most of their activity dealing with Rwandan cases, et cetera, from say 20 years ago. Now Liberian cases. People that were involved in crimes 20 years ago came and changed their name, and the the victims start seeing them and demand that there be some action in those cases. Those are often low-level people. And so there's kind of targets of opportunity. I think there needs to be, the IIM can be working together with the Eurojust network that Klaus used to supervise and that our friend Mateos is in charge of, and that'll be meeting next month in The Hague. One of the thrilling things that's happening, the French and the Germans now have a JIT, a Joint Investigative Team, and that was very important, I think, in making the arrest that's now going to lead to this trial in Berlin that Christian will be proceeding against a colonel who is involved in general intelligence and allegedly in torture, Anwar R. But the arrest of him and 2 others was done in coordination between France and the United Kingdom, with their investigators able to cross borders and not have to go through MLAT proceedings between the states, et cetera. So there's some positive things that are happening, and if we can sort of put all of this together, and different states can do the cases that they can specialize in, we can begin to, I think, accomplish more than we hoped. You know, as I said, I'm always an optimist. Give me a damp glass, and I'll tell you it's half full. So, and this glass is indeed half full at least.
So our second mechanism that we're going to talk about is UNITAD, which is kind of a different character because it's one-sided, and maybe you want to comment. I note in the past we generally have tribunals with jurisdiction over a situation. We generally haven't said over a certain set of perpetrators. But this is what the Security Council has passed. And, is this, what does this say in terms of precedent? But I think more puzzlingly, you talked about what the IIIM is going to be doing with some of its evidence, working with other countries, but what is UNITAD going to do with its evidence? And we were talking yesterday by email chat on the terms of reference. In the Syria mechanism, I see very clearly we won't turn over evidence to countries that utilize the death penalty, and we will only turn over evidence to countries that have fair trial protections. I don't see this in the UNITAD terms of reference, but there is this oblique reference to UN best practices that might be requiring this. It is possible. But doesn't a UN mechanism have difficulties? Can it really feed, this is paid through, I think it's both assessed and voluntary, but part of the money is coming from the UN. And Iraq has the death penalty. They've been using the death penalty, and I think we have to be alarmed with very quick trials. How is this going to work? What is UNITAD going to do with its evidence?
Well, I wish Karim Khan here would answer. I see my friend Sarita Ashraf, who worked with UNITAD for a while, and maybe she could respond later in terms of how they're operating. Do keep in mind that the General Assembly, by a vote of 105 to 15, adopted the Syria mechanism, and initially supported by only voluntary contributions. So Catherine's with the Fifth Committee trying to get maybe some of that paid by assessed contributions, because raising the funds year after year and doing something that's not particularly visible is going to be real challenging. The Myanmar mechanism, because it came through the Human Rights Council and had a very heavy vote, 145 to 12 in the Fifth Committee and the Third Committee, is getting funding from the UN, from assessed contributions, to the extent people are paying their assessments in the UN, but, and can raise money on the side as well. UNITAD was created by the Security Council and was created through a consensus process that took frankly, a whole year to negotiate. And it was a process in which all of the states were extremely respectful of Iraq, who had, it wasn't, I mean, obviously there were countries that assisted Iraq in defeating ISIS, and there was loss of blood and treasure on the part of allies, but the vast majority of the work of defeating ISIS was done by Iraq. And so the idea we're going to tell you what to do is something countries didn't want to do. And frankly, having spent a lot of time in Iraq, and of course you get different answers in Erbil and Baghdad in terms of what they want to do, but a lot of us at the international level thought that the that the Iraqi High Tribunal that tried Saddam Hussein and Chemical Alley wasn't sufficiently internationalized. You talk to most Iraqis, they say it was too internationalized. It was you guys, et cetera. And so their solid rule this time is, it's our country, it's our system, we're going to do it through our system. We want your help in building our system, and to a large extent, we'll tell you where we need that help. And that's essentially because the international community wants very much to see accountability for crimes like the genocide of the Yazidi, as the Syria Commission, frankly, found that there was a genocide there. They want to see accountability. Where is that going to happen? Maybe there's a case in Germany right now because of the refugees that went to Stuttgart, but it's going to happen the perpetrators are being held. I mean, obviously there's some being held in Syria, maybe today, but certainly thousands of them in alleged perpetrators, different roles, different individuals being held in Iraq. So that's where you could have justice. Now, but the whole process was this negotiation where Iraq had to accept it, and then the same with the terms of reference, which actually were provided in the resolution, had to be approved by the Security Council as well. And so whereas in the GA passed Syria mechanism, this leads the terms of reference that says the Syria mechanism shall share its information only with jurisdictions who respect international human rights law, and including the right to fair trial, and the death penalty shall not apply to offenses under consideration. When it comes to the terms of reference of UNITAD, it's the information will be shared primarily with the Iraqis. That's intended to be the basic destination, though information can be shared with others, and Kareem will tell you he shared information and helped recently in a Finnish case in Finland, so it's not just Iraqis. But anyway, it would be in accordance, as you say, with UN policies and best practices and relevant international law, including human rights law, but no mention there of the death penalty. There had been, I'm informed, originally a provision that was insisted on within the UN that there be a death penalty provision that was stricken in favor of a compromise, which is now in paragraph 45 of the rules, which says the investigative team, which is what it's called, the UN investigative team against Daesh, only one side, shall liaise and coordinate with an Iraqi steering committee or competent Iraqi authorities on modalities for the eventual use of evidence collected by the IT. Now, I think fundamentally this means that, given UN standards, et cetera, that information won't be shared with the Iraqis if it is information of individual criminal responsibility that can be used to hold an individual to account in a death penalty trial. And that I think means that the UNITAD is focusing a lot of its attention on what we would call sort of the crime base, working with, say, the ICMP right now and finally getting to the mass graves and identifying the victims in those mass graves, which does tell you something about the pattern of violations and can tell you something impliedly about intent to commit genocide, say, against the Yazidis or Christians or others. And so, but then when you get to issues like, for instance, the telephones, and almost all ISIS members had smartphones and laptops that are seized on the battlefield, that getting to that material, it might really give you some information about who's communicating with whom and where they're going and and to some extent separating the men from the boys. If the UN gets that, and they don't have it yet, then the question will be if they analyze it and then they turn it back to the Iraqis and say, these 10 guys are the worst of the worst, obviously the Iraqis would seek a death penalty. So this will be complicated, as a result of which the Iraqis probably won't provide that material. And then will it be analyzed at all? Yeah. And so that's part of the challenge of this deal. Yeah. On the other hand, there's a lot that needs to be done and a lot of things that need to be coordinated and information that needs to be gathered. And it is the strange thing in our world that we have this horrible, frankly, genocidal crime committed by a non-state actor that nobody in the world likes, that doesn't have a vote in the UN, et cetera, no friends. And even there, we have a hard time getting to what we would call independent justice.
Yeah, and I know you were talking with some states who are interested in creating a tribunal, and there have been a couple of possibilities put forth because of this quandary. I think about the evidence, and I know there was a meeting in Sweden on this issue. Some other states have explored other possibilities. One of our friends and colleagues was interested in creating a hybrid model in the Kurdish areas. And the Bosnia State Court is actually our hybrid with the greatest capacity. It's done the most cases. And something like that. And a hybrid has the advantage you're using a court system that is already there, and you could build on that. But you've been, I think, involved in some other exploratory discussions because there may be some mechanism that is not yet envisioned.
Right, and understand, I mean, I'm largely involved because Siege has grants from various donors to assist both the Kurdish region and the Iraqi central authorities on building the capacity of their system. And so we're familiar with this and talk to them a lot. I think in principle, the Kurdish, the authorities of the Kurdistan region of Iraq generally would, I think, accept having a hybrid court. They do have the ability to pass a statute through the Erbil Parliament to put in, to actually bring in IHL, International Criminal Law. They have aspects of their criminal code that are different than Baghdad. They have a domestic violence statute that they don't have in Baghdad. They can establish divisions of courts. They can establish who's going to serve, even foreigners. All of that they could do. Their concern is that they don't have the resources to do it on their own. They want the international community to assist, and frankly, the international community doesn't want to be involved in negotiating with an autonomous region if the capital doesn't agree. And so that the barrier to going forward with the Kurdish region is frankly states, EU, US, UK, et cetera, say whatever we do in this region it must be something that's okay with Baghdad. And as a result, there may be some efforts to help capacity building in the Kurdish region. And we had this whole referendum, which of course further increased tensions for a period of time. It doesn't look like that's moving. There's some hope. I saw Minister Le Drian of France is going to Iraq again to talk about some possibilities. I think that the promise of doing something in the Kurdish region is probably the strongest, but it would take understandings with Baghdad. I think maybe encourage both sides to do the right thing and have a kind of a model of different parts of the country, different parts of the Federal Republic, try to do things in a positive way, and that might cause the trials to be ones that would meet standards. The other challenge is on the Syria side, and putting aside the events of in the last 2 weeks and the Turkish invasion of northern Syria and the area that had been controlled by the Syrian Democratic Forces, we've had around 12,000 ex-ISIS fighters that were being detained with some Western and U.S. assistance in that region, and as we know, about 72,000 dependents. And of those that are being detained, maybe 1,500 are foreign terrorist fighters, so-called, coming from Western countries, and about 12,000 of the dependents are in that same situation. And a number of Western countries don't want to accept even their own citizens back. And this is particularly challenging for countries, say, like Sweden, which doesn't have even a material support of terrorism statute. Even if they prove ISIS is a terrorist organization, they can't prosecute for material support. They need to prosecute for war crimes, crimes against humanity, et cetera. And the challenge there is having the evidence of individual criminal responsibility in the absence of investigative efforts and exploration of the cell phones and all of that kind of thing. And so if they bring somebody back, they may not be able to charge them. And so you have this political pressure. I frankly think the major efforts should be made in supporting the documentation and building the files and bringing people home to the countries they come from. That should be the goal. But there was discussion of two approaches, one of which trials could be conducted in that region by the non-state actor under principles that are established even by the ICRC, in which non-state actors can conduct trials in the same way that an occupied state can, using the national law, but good judges, et cetera. And But that's complicated for a lot of countries because obviously Baghdad or Damascus doesn't want that. And we don't want these people going into the torture centers of Damascus. That would, be a real disaster. So that's not a solution. Another solution was the various states could create a pooled jurisdiction court, and that's what was discussed. And there's a public opinion by Professor Nolkamper of the University of Amsterdam that discusses that idea. There's been talk variously, sometimes of pooling universal jurisdiction, which is intriguing, but this would be pooling active personality jurisdiction. The states who sign up would try their own citizens. They would write a statute that reflects customary international law. They would develop the evidence. Of course, then where would they try them? In Qamishli, which is under attack by the Turks today, or ships at sea, or would they work some arrangement with some country in the region to host the trial with what would have to be a rather intensive amount of security? But that was also under consideration. It does indicate that sometimes, you get a crisis and people began to think of some creative ideas, but thus far, and particularly with the crisis of security and now questions whether there's escapes and who can guard the people that are there with the SDF fighting a war and needing every soldier to fight the war and not to guard, we're really into a kind of situation where people can escape and this organization that, strong evidence committed genocide could be back in business, which would be a real tragedy. So, en verra, as the French say.
For the Myanmar mechanism, I know is just starting its work, and maybe that one, I guess, maybe has the most obvious venue because the ICC, and I guess it will have to work out its relationship with the ICC, but the ICC has jurisdiction over crimes that at least an element of the crime occurred in the territory of Bangladesh. So that one is probably the most obvious venue for a certain subset of the crimes. I don't know, it's just starting off. If it's probably too soon to predict where it could go beyond the ICC attempting to do this, trans-border kind of crimes. But any crime that was purely in Myanmar, would not be part of that.
Well, indeed, the good news about the Myanmar mechanism is that it had strong support in the General Assembly because European countries, Latin American countries, African countries, Islamic countries unified around this idea. But it's harder to figure out the destination for the material in national systems because it's not like Germany, which has 800,000 Syrian refugees. There are not a lot of people that have countries that are doing these kinds of cases that have Rohingya refugees, for instance. And there isn't a tradition, even in Australia, of doing these kinds of cases. And so that sort of option isn't very obvious at the moment. And the sort of views of universal jurisdiction now is it was controversial and pushed back in the aughts, but now people are saying, well, if a country really does have a lot of impact from the crime, then there is justification. And certainly if a perpetrator is present, but we're going to see less of that in this context. So we do have the ICC case on forced deportation where the prosecutor is seeking approval of the pretrial chamber, and the pretrial chamber, in a sense, almost invited that application. So I think we're optimistic that we'll see that, and that can be an eventual destination for some of the material, of course, only dealing with that amounts to forced deportation and not to the alleged violations, the violations found by the fact-finding mission in other regions of the country, such as in Kachin or Karen or Shan states. So anyway, there is that possibility. It is our Nick Kumjan, who's been a veteran of the ICTY and the Special Court for Sierra Leone, and a member of our Taylor team, and then, of course, a defense attorney at the ICC, and then now, most recently, the international co-prosecutor at the ECCC is the head of it. And he's got 3 little offices in the Palais des Nations right now, but it's building. And it's not collecting evidence on political or on linkage is more challenging, I think, in Rakhine State than it was in parts of Syria, which fell at one time or another to the opposition. But there is an enormous amount of evidence that's with the social media because as the fact-finding mission found, and here again we had a commission of inquiry that did fantastic reports, 2 of them, and then recommended that it go out of business and be succeeded by this mechanism. But they found tremendous evidence that the social media, particularly by the military, accounts that had up to 1 million followers were used to incite hatred and violence against the Rohingya people. Well, that evidence could be accessible in the United States, for instance, with Facebook. So there are places where evidence potentially with cooperation could be found and developed. And of course, there are 700,000 refugees that were forced out in these camps. On the other hand, there was hope that this would be headquartered in the region, but none of the countries in the region wanted to host it. ASEAN is not used to accountability issues, et cetera, and it's now being headquartered in Geneva with limited resources thus far to travel. So it does have its challenges, but the work is beginning, and we shall see. One intriguing thing Nick mentioned, and there was some discussion a little bit ago about corporate liability and that kind of thing, but the fact-finding mission did find in its last report that was just issued in Geneva last month, as it finished its work, enormous indication that the Tatmadaw, the Burmese military, is a business and is doing all sorts of things for profit, et cetera, and the ability to potentially sanction parts of those companies or those organizations that are benefiting from these crimes exists under, whether you could get it in the UN with the Chinese veto, I doubt, but you would, with Magnitsky sanctions such as we have in the US, where we've already listed some of the generals, the global Magnitsky or human rights sanctions. Britain established them in 2018. The European Parliament in March voted for Magnitsky sanctions to be established across Europe. And so this is a tool that could be used, and Nick said that he would be prepared to share his information with national authorities that were building packages for sanctions. And we know that one of the due process issues, which we see in cases like the Kadi case before the European Court of Justice, is that sometimes the facts that support the sanctions aren't that strong, or they're only with intelligence community and they won't share them. So you could, these mechanisms could provide a tool for more effective human rights sanctions that eventually could open the way for national prosecutions, for instance, of companies that were then dealing with those that were benefiting from these crimes. So there could be other ways. Again, it's indirect, but other ways that this information would be used to achieve some measure of accountability, to take the incentive out of the mix under which the commission of these crimes unfortunately seems to pay for certain political and economic leaders.
Maybe this is fascinating, a lot of food for thought, and a lot of challenges ahead. But so for these are 3 different mechanisms created different ways, different terms of reference. Is this a good idea to create different investigative mechanisms? Is there potential for the creation of a permanent investigative mechanism body?
Well, the idea has been proposed. Our friends from the International Commission of Jurists, Sam Zarifi and Kingsley Abbott, have written suggesting the idea. But I'm skeptical, knowing the Human Rights Council doesn't react to the same situations in the same way. So establishing a single mechanism where its director could decide where he or she was going to investigate today, I don't think would be something that could occur. I do think, however, having a mechanism or the resources of this mechanism to assist on other mandates would be very useful. I mean, I mentioned these other examples, South Sudan, for instance. We've had an AU Commission of Inquiry under former President Obasanjo, which did a great report, and then you've had now this Commission of Human Rights for South Sudan, headed by Yasmin Suka of South Africa, and it last year said it had collected 58,000 pages of documents from the military in South Sudan, but it doesn't have the resources yet in Geneva to collate that material, to put it on a computer, to do any kind of analytics with it, et cetera. And you have other, next month there's you know, Angelina Jolie, William Hague Summit 2.0 on sexual violence in the UK, and discussion at one time of having a global mechanism on sexual violence crimes, et cetera. So there's a fair amount of interest in this, and I think that that there's no question that all of these commissions, to the extent that we'll be using the Human Rights Council or the General Assembly as a way to build investigative files, we want to make sure that they have the capacity to do that. And that's not just in Myanmar and Syria and Iraq. It could be elsewhere. And so it's a challenge that I'm beginning to work on, you know, with some colleagues at Oxford, trying and pulling together to try to figure out what the best, most efficient way is. But I mean, you know, we'll have to see what the international community is prepared to do. But I think a lot of us, when we started looking at this 3 or 4 years ago, would be surprised that we would have gone the way that we've done. And it shows that even with all of the headwinds against accountability, it's still possible to make some progress.
Yeah, great. Thanks so much, Steve, for that. So turning next to Dire Talati, Professor of International Law, University of Pretoria, Extraordinary Professor at the University of Stellenbosch, South Africa's member on the International Law Commission, Special Rapporteur on Peremptory Norms of General International Law, Jus Cogens, and has served as Principal Legal Advisor to South Africa in South Africa and the UN. So thank you, Dire, for being here. So first, let me just ask about the role of the General Assembly in advancing international criminal law, advancing accountability. You know, what potential, what could we look to this body in the future?
So thank you very much. It's good to be here. It's my first time at the forum, and I think that the discussions have been absolutely fantastic right from the morning. I think both speakers this morning, in this particular panel have also been very inspiring, so I'm really glad to be here. The role of the General Assembly, I guess a lot of it has already been touched upon in terms of the mechanisms. So I would say there's sort of two potentials. I mean, one possibility is the role of the General Assembly once a conflict has already occurred and crimes have already occurred and there's a need for some accountability mechanisms. I think in that respect, Stephen has already spoken about some. But I think the most important role is in terms of standard setting, lawmaking, progressive development of international law. I do just want to say something though about mechanisms once crimes have already been committed. So one thing that we've spoken about, we've sort of touched on, and Ambassador Rapp has sort of alluded to a little bit, concerns the possibility that the General Assembly itself might be able to refer or create tribunals. I think as a legal matter, I don't think that there's anything that prevents this if it's done, of course, under the Uniting for Peace resolution, which, of course, raises its own complications and the technical arguments that can be made. But hey, there were technical arguments in the mid-1990s about ICTY and ICTR as well, right? So at least that's a possibility. One reason I think this is something useful to think about is another issue that has arisen in the course of this morning has been UN Security Council referrals or non-referrals in the situation of Syria, and why haven't they happened? Everyone who has spoken about it has assumed, it's been implied in the statements that these would be a good thing, right? So if there were referrals, this would be a good thing. I'm not sure that they would be a good thing. I think a lot of the difficulties that the ICC face today is because of the referrals, and in particular, the ways in which those referrals have been couched. You've mentioned one of them already, and I think was also mentioned in the afternoon, the financing. For me, that's the least of the problems with these Security Council resolutions and referrals, right? Because as you said, it is purported, so the General Assembly could decide if it wanted to, if it had the willpower to do so, it could decide that, hey, we are going to finance this because this falls within our mandate. There are deeper issues, though, with these referrals. Everyone is speaking about UJ, right, universal jurisdiction. These referrals, both of them, take away UJ in certain instances, and I think that's problematic. They say that in certain instances, I think it's in paragraph 6 of these resolutions, in certain instances, not only the ICC may not investigate and prosecute, but other states as well may not. I think these are deeply problematic. The biggest thing, the biggest explosion, difficulties that have arisen from these referrals, Leila spoke about it at length in the morning, and I know we disagree. I will try not to go there. On the immunity question, all of these problems go away if the Security Council drafts the resolution in a different way, right? They all go away, right? The resolution, it doesn't even have to mention immunity. All it has to say is all states shall cooperate, decide that all states shall cooperate. Boom, that's the end of the story, right? So I think from that perspective, it might in fact be useful to think about the possibility of UN security, the General Assembly involvement. Now, so the General Assembly could refer, but I'm not sure that as a legal matter, the ICC could take up the matter. That's the only problem. So states parties could think about amending the statute. There was a proposal a couple of years ago, in 2009, to amend the statute in respect of deferral.
Yes.
Why can't there be an amendment to amend the statute, a proposal to amend the statute in the context of referral? This, of course, creates all kinds of problems, right? I'm interested in power. It creates all kinds of problems for powerful states because suddenly there is no veto, right? So suddenly there is a possibility of a referral in situations where powerful states might not be happy with. So there are problems, but these are political problems, and I think as a matter of law, so there's certainly ways around these. I do want to say a couple of things though, about the role of the General Assembly for enhancing accountability mechanisms, at least in terms of, which I think is really ought to be the main role, at least in terms of the development of law and codification of law, progressive development and so on. The General Assembly has on its agenda a couple of topics that are relevant, right? So one topic that's relevant is the criminal accountability of UN officials. We never speak about these, but of course we all know that they also commit crimes in the context of conflict, and I think it's useful to also think about the, making progress at least in respect of this one agenda. One agenda item that's particularly relevant for atrocity crimes, obviously the other one is not directly relevant for atrocity crime, is universal jurisdiction, which has been on the agenda of the General Assembly since 2009. I was at the time a representative of South Africa in the General Assembly, and I attended one meeting a couple of years ago, about 2 years ago, and I said to a colleague sitting next to me that I could have given the exact same statement that I gave in 2009, I could have given yesterday on that statement. That is just an indication of how little progress there is. Now, luckily, of course, states are continuing to exercise their universal jurisdiction, but I think it would be useful also in the context of the General Assembly for there to be some progress in terms of at least identifying the scope, the limits, and so on. In terms of its current program of the General Assembly, perhaps the most useful and most relevant contribution that the General Assembly could make is in response to the work of the International Law Commission. A couple of times in the course of today, we've heard about the Crimes Against Humanity Convention. Starting on the 28th, of course, the General Assembly will be debating the report of the ILC, and I'm sure this is the biggest topic that the General Assembly will be focused on. What kind of a decision the General Assembly will take with respect to that, I think is going to be hugely important. But it's not the only one. The topic on immunities is a extremely important topic. As I've said, I disagree very strongly with the judgment of the ICC in the Jordan appeal, and we can talk about the merits and demerits of that. I won't raise it myself, but I am sort of hoping that somebody does point that question at me. What I think is important, though, is how we're so focused on this one particular issue of immunity, the Bashir immunity, that we've lost complete focus on a broader question. And this broader question is the work of the ILC and whether or not the states from which we come are supportive of this draft Article 7 that Leila spoke about this morning. This is not about the most important. It's not about the troika. It's not about the head of state, head of government. It's about normal officials. And even there, the General Assembly is unable to reach agreement that, yes, the ILC is correct when it says that there are exceptions to immunity ratio in materia. That, from my perspective, is really where we ought to focus. If we cannot find agreement on that, it's difficult for me to see how we can find agreement sort of on the question of immunity ratio in personae. I mean, there are other questions as well. There's a question of whether or not we should leave this topic, universal jurisdiction, in the agenda of the ILC, or whether it should be transferred to the ILC. My colleague Charles Jallo has proposed that the ILC take up the topic, and it's an excellent topic, excellent proposal, but the General Assembly is reluctant to allow the ILC to address it. Again, I think some pressure could be placed on the General Assembly to push for the ILC to finalize it. There's also, of course, a topic for which I'm responsible on peremptory norms of general international law, where I think it would be possible for the General Assembly to offer some support in the context of criminal prosecutions and investigations. There had been in a report that I had presented, there had been a proposal. That proposal, again, was shot down very much along the lines of draft Article 7. But of course, again, if the General Assembly were to be supportive of that and were to ask the ILC, why do you not have a provision on immunity along the lines that Leila mentioned in the morning, that would be helpful. So these are all, I think, the kinds of contributions that the General Assembly could make.
So, Dira, since you've worked on the Crimes Against Humanity Convention, can you maybe tell, probably most in the audience are persuaded we need one because it's a gap in the law, but maybe states would say, don't we already have a definition of crimes against humanity in the Rome Statute? Why would we need another one? Does this add more than what we have in the Rome Statute? Can you address that?
I mean, I think the crimes against humanity topic, of course, as a lot of you have mentioned, is an important one. The idea of seeking a convention. The very first thing that the ILC had to think about in proceeding with this convention was its relationship to the Rome Statute. And there were, you might remember, in the very early days, I believe it was 2013, 2014, there were some concerns that this could in some ways undermine the Rome Statute. Of course, these have very different focus areas, right? So the Rome Statute, of course, is focused on the ICC itself exercising jurisdiction, but this convention would really be there to encourage states and to create an obligation on states to exercise jurisdiction. In a sense, and this was kind of the mantra that we began with in the early days of working on this topic, at least within the ILC. I know that there was a lot of work done before that, but within the ILC, one of the mantra, so that we rallied behind was that this, in fact, would be a way to put in play and to implement complementarity, or positive complementarity, by putting in the tools that would allow states to exercise their jurisdiction. So absolutely, I think it would be an important contribution of the General Assembly were to move forward with this crimes against humanity. I, as you know, never see things in black and white, and so there are issues that have to be taken into account when you are thinking about the Crimes Against Humanity Convention. My own personal views with respect to the draft articles that the Commission has worked on is that really what we ought to be focusing on. So for me, the most important contribution that this convention will make is not the definition. That's not the most important contribution that this convention would be making. The most important contribution that this convention would be making is that it would be putting in place a very robust interstate cooperation mechanism, including the extradite to prosecute, the extradite or prosecute obligation. That, for me, is the most important contribution. If that is the case, and that's not necessarily shared by everyone within the Commission, but if that is the case, then I think there is a value in contemplating whether or not the gap that's identified in the Commission's work, and that has been referred to in this room today, is in fact really the only gap. Does this gap also not apply to genocide? I mean, yeah, sure, there is a genocide convention, and but we don't have the robust interstate cooperation mechanism that we are foreseeing for this instrument. And so one of the things that I've pushed for in the Commission, unsuccessfully, as is often the case, is I pushed for a broader scope to the Crimes Against Humanity draft articles. And so that's, I hope, is one thing that'll come up. I mean, the special rapporteur, when I had first raised this, didn't even think twice about it. But there have been sufficient comments from states to say, we think that this is something that ought to be thought about, that it is very possible that once the General Assembly begins a negotiation text on a Crimes Against Humanity Convention, that this may well be something that might come up. One thing before you stop me is in pushing very hard for a Crimes Against Humanity Convention, the thought crossed my mind as I was listening to Leila this morning about the things that you also need to be careful about, right? So pushing for a convention essentially permits states some level of control. States have some influence in the work of the Commission, but they don't have a level of control in the work of the Commission. If you start a negotiating process, states suddenly have full control. So there is a question of draft Article 6 and immunities in the Crimes Against Humanity draft articles, and their immunity is not touched upon. What is touched upon is the responsibility provision. Now, of course, you may say, yes, but this means immunity. Yet if you look at the commentary makes it very clear that there is a difference between immunity and what is covered here. So the distinction that Leila spoke about, that some of us, myself included, make between the Nuremberg Principle and Article 27, Paragraph 2 of the Rome Statute, is made in that article, and it's foreseeable, it's very likely that in a negotiating process, the question of immunity is going to arise, and I don't think that if a question of immunity arises, that states are going to say the Troika does not, or immunity ratione personae does not attract immunity. You can expect that states, in fact, will likely pull in a different direction, and that's something that I think you have to think about. Yeah.
Dear, since you're here and from South Africa, and I know ICC is not the focus of this conference, but I do want to ask, South Africa has historically been a leader in terms of the ICC, and then we saw the announcement it was withdrawing. Then it didn't withdraw, but I've heard the issue is newly back or never exactly left South Africa's parliament. So this issue has sprung back. What's going on in South Africa on the ICC?
So of course I was very involved in the initial discussions because I was with government at the time. I was in government both at the time when you described that South Africa was a big friend of the ICC. In fact, I would say, given everything that was happening, was certainly one of the biggest friends because it sort of tried to play this let's bring everyone together role, and of course things changed in 2015. And I'm not in government now, so I don't really know what's happening, but I've also heard. My understanding is that there is a policy decision that has been made by the ruling party, and that policy decision is that there ought to be withdrawal. There had already been, before the last election, a tabling of the documents that would start off a withdrawal process, and it stalled a little bit after the elections and it died down, but it has since been raised. My guess is that that Parliament will not proceed with this. I mean, it's just a guess at this point, it's not based on anything, but there is a thing on the agenda, and that thing on the agenda has to be addressed, so of course it makes sense that it would at some point arise.
Yeah. So I have maybe one last question on Jus Cogens, crime against humanity, and then I think we'll go to audience questions, so please think of your questions. So as special rapporteur, I wanted to ask you a question because I've been writing on the veto and questioning the legality of using it while there's ongoing atrocity crimes, and whether that's really in accordance with the UN Charter, which is what it would need to be. because it's the council, and the council is created under the charter, so it doesn't have power greater than the charter. It can't be violating the charter. But I was also looking at issues of jus cogens, because we say genocide, war crimes, crimes against humanity have this highest level protection, and the veto, of course, is then found in the charter, which is lower in the hierarchy of norms. So it's at minimum inconsistent with jus cogens. And I was also looking at the obligation to prevent genocide, an obligation to ensure respect for Geneva Conventions. And if we have a new Crimes Against Humanity Convention, then we will have an obligation to prevent crimes against humanity. It would seem also inconsistent with the treaty obligations of these to use the veto if these crimes are ongoing. So I was looking very technically at the legal arguments against this, and I don't know that Navi's in the room, but I actually have an initiative working on this, and ICTJ and OSJI, I think, are both here, and they've been supporting this initiative, and Navi is one of the individual sponsors of it. And I'm very appreciative of this support. And the goal is to, for the General Assembly to ask this question of the ICJ: is it fully legal to use the veto while there's ongoing atrocity crimes? But in the course of doing my research, I was looking at these statements: oh, war crimes are jus cogens, crimes against humanity are jus cogens. But this audience will know our formulations differ. Genocide stays the same, but war crimes, crimes against humanity evolved from Nuremberg, ICDY, ICDR, ICC statutes. They're all different definitions. So when we say war crimes are jus cogens, what do we mean? Sometimes it's said intransgressible rules of IHL are the jus cogens norm. So I was trying to figure out what is the jus cogens norm. Similarly, on crimes against humanity, we have different underlying crimes underlying it. So when we say crimes against humanity, I'm not sure which definition is being referenced. Can you help me shed any light on this?
So I will comment on a couple of the things that you mentioned first before answering your question. First of all, I would very strongly advise against requesting an advice, and I'm going to tell you why, requesting an advisory opinion from the ICJ on the question that you ask if you're looking for a particular answer. If you're interested in the answer just out of curiosity and intellectual interest, then go ahead. But if you're interested in a particular answer, then I'm afraid that you're going to be rather disappointed by the answer that you're going to get from the ICJ.
It is possible. We are exploring other venues as well
so I'm
for
just saying
pushing
that.
on this.
And then on the question of sort of one thing we need to understand about the work of the ILC and an International Law Commission is that, in general, the Law Commission is a rather conservative body. That's just the nature of the thing. Methodology of international law is particularly important, and so it's not the place to go to for these really progressive. Now, of course, there have been very interesting examples. We know about the Nuremberg Principles, but of course, in the Nuremberg Principles, the General Assembly specifically said to the ILC, "We want you to drop these principles that come from this." It had no choice, and in fact, if you look at the Nuremberg Principles, the Commission doesn't really bind itself to this. It says, yeah, these are the principles that came out of this. It is true that in the 1996 draft code, we see a very progressive ILC, but it's not the norm. And it's certainly not different with jus cogens. I mean, with jus cogens, something as fundamental as sort of saying that norms of jus cogens are those that protect and reflect the fundamental interests of the international community of states was very difficult to have adopted within the ILC. On the question of the Security Council in particular, whether or not the Council is bound by norms of jus cogens, that was a huge discussion. One member, I mean, these discussions are public, so I can say who, Mr. Huang from China said, the Council is bound only by one thing, and the only thing that binds the Council are the procedural rules in Article 27. That's it. Once you've got the votes, that's the end of the matter. So the ILC wasn't even able, at least not in the text, to specify that the UN Security Council is bound. I mean, there is a draft conclusion that says, decisions of international organizations and so on must comply with use cogents or else they don't come into existence or create obligations and so on. But to specifically, explicitly mention the UN Security Council was difficult. It is in the commentary, but it was difficult. With respect to the question that you specifically asked me about the norms that have been identified in the different formulation, it was always a question mark whether or not the Commission would have some kind of a list of norms of use cogents. It was very difficult. From a methodological perspective, if you're going to have a list, you would need to apply the very rigorous method that the Commission itself had set out, and if that's the case, then there's no way that we can finish the project now. I mean, the project was, as one member said, you would need either 5 minutes or 50 years. And we took the 5 minutes approach, which is to say, let's identify those norms and use the same language, which goes to your question, that the ILC has in the past said were use cogents norms. With respect to war crimes, the particular phrase that we use came from the commentary to draft Article 26 of the Articles on State Responsibility, and it was the most serious violations of international humanitarian law. That's the language that we use, with the understanding, of course, that it might be understood, or that different terminology might be used in different places.
Yeah. You say the ILC is conservative, but the Articles on State Responsibility actually set out a lot of obligations, including to coordinated action to try to end atrocity crimes. So there's actually some good stuff in there.
There is some good stuff,
yeah.
But you do know that that particular provision that you speak about, so it's the provision to cooperate to end violations and not to render assistance and not to recognize situations that are caused by peremptory or by breaches of peremptory norms only applies to quote-unquote serious breaches. And one of the things that we try to do now is to say, well, all breaches of peremptory norms are serious, so let's get rid of this word. These obligations apply in all instances. And the Commission wasn't able to agree to that, so we've retained the word serious. So it's still,
But the atrocity crimes we're usually looking at usually would fall in that. So we'll do one last thing and then really go to the audience for questions, because you wanted, I think we didn't finally get to fully to what your concern with the crime of aggression, and you had kind of suggested maybe it is hitting too close to some powerful countries. And what we didn't discuss was the truncation of jurisdiction that happened with the activating decision. And, there was an agreement in Kampala in 2010 on the definitions and conditions for the exercise of jurisdiction. And then at the Assembly of State Parties, that was very much changed. It was really the UK and France insisting on changes to jurisdiction. There may still be a legal question as to the full legality, because we were both there at activation, and many states stood up and said, we do not believe that this is the agreement on jurisdiction. What do you make of all of this?
So yeah, I mean, I said it as a suggestion, but the reality is that it is a fact. I mean, it is a fact that that we have the difficulty that we have with crimes against humanity, because it does, with the crime of aggression, because it does hit close to home for powerful states. That is without question a fact. So I was involved in the negotiations, at least from 2007, and right up until Kampala, so with the negotiation of the text. And I can remember, a lot of my very good US friends in the delegation I met in that context, and I can remember that in 2000, at the Assembly of States Parties in 2009, the US had the biggest delegation. It's not a state party, by the way, but it had the biggest delegation, and everyone was excited. Thank you, welcome back, we are ready to meet you with open arms. And I was the only skeptical guy out there saying, this is not the Obama magic. I mean, this is about the crime of aggression. This is not we're coming back to be partners. And of course, it's because it's so fundamentally important. Now, one argument is, well, the US is not really concerned because it's not a party, it's not going to be affected. But I also know that the US is very concerned that its allies, that often they have to rely on to engage may be prosecuted and may not want to engage in sort of use of force measures that the US. So it was very important not just that its own officials weren't liable for prosecution, but also that officials of others weren't liable for prosecution. You're right that the text that was eventually adopted could be read in different ways. I mean, I haven't looked at it in a while, but I certainly have a very broad reading of it, and there's nothing in the text of the amendment itself that restricts the jurisdiction one way or the other. It is, at least as far as I could read it, as long as the crime was committed in the territory of a state party that hasn't opted out, or it's committed by, or, not and, a national of a state party that hasn't opted out, then the ICC could exercise jurisdiction. So notwithstanding the declaratory interpretations that have since been issued on what it means, which relates to that truncated jurisdiction that you referred to.
I know I think we're getting too much in the weeds, but there is paragraph 5 to
The
fit
resolution,
the Kampala amendment that pretty clearly carves out non-state parties. So, but then we have a further tremendous reduction in jurisdiction in 2017. And just to mention, I mean, this is, I think, largely one of the legacies of Nuremberg. It's counts 1 and 2 were the crime of aggression, and you know, is this fulfilling the legacies? Has to be a topic for a different panel. Audience questions, please.
Oh, wow.
A lot. Oh, do I start? I pick.
Take 4 or 5 of them.
Okay, so we're gonna.
Cecile?
So I will need paper then. Yeah.
Thank you very much. Thank you very much for really great remarks and covering so much that it's difficult to ask. I mean, there would be so many questions for each of you. But if I may ask all 3 speakers to in fact express their views on what will make possible the establishment of a permanent investigative mechanism. Because we have been speaking of it, and we've been speaking of especially the one on Syria, and then followed by the one on Myanmar. And by the way, they have the very same terms of reference, with simply the name of the country being changed. So would you, each one of you, be in favor of that? And if so, what will make that possible? And I'd like to really just mention maybe one thing, though, regarding those mechanisms, which is that they're not only collecting information. Their mandate is really about the preservation of information and also the analysis of this information. But the preservation is a key element. And so what will be your views on the necessity to preserve documents and really how to best do that? Thank you.
Yeah, let's take maybe 3 questions. So here in the front and then behind.
Thank you very much. First, I just want to link up the first session and this, the first session about common elements, and hear about the procedures. And my question is, do you think that the international community is overspeeding in setting up mechanisms? And would that lead to confrontations or more resistance from national jurisdictions? For instance, collection of evidence, like Simon said, or even the said mention that the ICTY and ICTR provided the best examples of cooperation, with international body, but which is what we're not seeing today. Now, is the international community, by setting up multiple mechanisms, trying to erode national jurisdiction and therefore create stronger resistance? And is there a commonality in terms of definitions of criminal responsibility, both in international law and domestic fora? Because even when you talk about crime of genocide, a definition of crime of genocide in one legal system may differ from other. And how do you interpret that when you're collecting evidence, for instance? What is the definition of threshold, evidential threshold of genocide or crime against humanity, especially in the context of armed conflict or in context of where there's no armed conflict, So my question is with these mechanisms being emerging themselves, And also in Africa, we have regional bodies like the African Union, also creating its own mechanisms. Is there a time where we put a stop to that and say, well, let's empower national systems rather than in order to encourage complementarity?
And then maybe one more question just behind.
Good afternoon. My name is Xavier Jean Keita. I'm the Principal Counsel of a Defense Office in ICC. Thank you for your panel. I totally agree that UN Security Council role was to cover a kind of gap for ICC role. And I totally agree with Dudley that maybe the Assembly General should be the one filling that kind of gap. My question is, because we are talking about accountability, what about our accountability as an international community when we remain totally silent because a state is simply using his veto, and for me veto is now totally obsolete, and while crimes against humanity and war crimes are committed, we are academic, we are professional, but I never hear our community of professionals voicing against this kind of situation. And I do think that our silence is a kind of complicity. So my question about that, don't you think that it's time to have a kind of call or statement of Nuremberg asking for removing the veto? And my last question is for my dear friend Ambassador Rapp. We have a kind of complicity. Anytime I see him in public, I ask the same question. Dear Ambassador, when the US are going to join the ICC? Thank you.
Well, start whichever you want to address.
Thank you. Well, permanent investigative mechanism, or, you know, when I had the privilege of being in Lebanon from 2006 to 2008, and we were there together, when the investigation commission was put in place after the assassination of the former Prime Minister Rafik Hariri, you know, it was a very, very difficult time for all of us. We arrived there, a few individuals, little budget, little resources. We discovered the UN rules where on one hand you have a 6 months mandate and then you are told and to hire staff members it takes 7 months. So there were a lot of totally contradiction which were extremely frustrating. So after my 2 years there, I wrote a long letter to the Secretary General saying, look, why are we not creating a permanent investigation commission within the UN, making all those arguments, 12 pages explained with a concept note why I would say, you know, why are we reinventing the wheel every time? We should have a number of a kind of judicial firefighters with a limited number of individuals, prosecutors, investigators, forensics, to really secure evidence as quickly as possible, to make an evaluation about what is needed in terms of national support, investigation commission or referral, and of course have proper documentation management because everything was reinvented. And you know, I had some of our interns working on all the different investigation commission over the previous 20 years and all the recommendation and all the problems which had always been mentioned. And the result was some irritations because there was a discussion if this is something more for Geneva or something for New York. And at the end of the day, there was no really willingness to move forward. We now speak about a permanent investigative mechanism, and move to the second question to answer if this is somehow undermining the national jurisdiction if there are now so many different mechanisms. I think it's the opposite. Obviously, there is no appetite for referral to the ICC. Obviously, there's no appetite to create new tribunals. The best the international community can agree with today is to have more support mechanism, which brings me quite often to the conclusion to say that, well, the future of international criminal justice is very much domestic, and those different mechanisms have all mainly as an objective to collect information, to collect evidence in order to allow national authorities to do their job. It is a dynamic which needs to be found. It is not always very easy in national jurisdiction to use in national proceedings evidence which has been collected by others, but I think it's more, definitely much more in support of national jurisdiction than in competition. The last point about when the US are joining, this is of course not for me. And the call for Nuremberg, well, I think, of course, in the world today, to have a veto power doesn't make any sense in relation definitely to an organization which has as a main objective to preserve peace and security in the world, and where the highest number of vetoes is used in the context of preserving security and peace in the world. And of course, there have been initiatives where it was asked at least not to have a veto in relation to those specific areas. But we all know that there is a long debate already ongoing for many years about Security Council reform. But I don't think this is for tomorrow, and every reform in this regard could be vetoed. So I don't think it is for tomorrow or after tomorrow.
Yeah.
Steve?
On the question of a permanent mechanism, I mean, from my own point of view, I'd like to see that. You know, I think that if to get there, however, we would, you know, it would have to be something that would depend on mandates. It wouldn't be something where you'd have an independent director who'd get up one morning and say, I think I'll deal with Nicaragua today, et cetera. There would have to be a mandate to this mission to do something specifically. And of course, it would be coming from a political body, presumably from the Human Rights Council or the General Assembly, and so that not all mandates would be created equal. And we see that right now in the Human Rights Council, where something like, the Yemen mechanism, which initially went through, the Yemen, commission, which wasn't called a commission, it was a group of experts, or eminent experts, was supposed to talk about the facts and circumstances, et cetera. So it wasn't this, determine whether there are violations, determine responsibilities. So it'll vary from place to place. But I think what Cecile is getting to is that there's a profound need for capacity. And the model of commissions, of course, these have been around for a while. We've had, like, the Baziuni one on the Balkans that lasted a couple years, others that lasted only 6 months or a year. We now have the Syria one that's been in business for 8 years. But one of the challenges is when they go out of business, the material goes to the High Commissioner. Does the High Commissioner have the resources to respond to requests from national authorities who may need information a dozen years later? If information has come from a witness that's is guaranteed confidentiality, who's going to go contact that witness? You can't tell the nationals to do it because the witness didn't agree to that. So you need this ability to sort of follow on that material, and then of course we've got the technical issues. I mean, a lot of what's even people involved in the Geneva process will say, we're still in the 1990s. We're taking oral statements from witnesses now, the use of social media, or going beyond that. If one can obtain the cell phones of militia, et cetera, and you can analyze that and use the new tools like relativity media to analyze it, et cetera, and to build pattern evidence. There's enormous tools that are out there that should be used and that aren't available, and that if you had a mechanism, it could bring those tools to bear. And so I think in principle, it's something that we should see. Now, whether, since we've already created a couple, are we going to get rid of those right away and roll them into the whole thing? I think they'll want to get going and show what they can do as models, and then I think we then have to look at what should the others do, and it may be possible eventually to combine them all in one place. But it is, at the end of the day, fundamentally about having the tools that are needed to build solid investigations and aid accountability processes when they become possible. Yeah, I mean, I would certainly agree with Serge on the question of these processes actually helping national systems. Now, do keep in mind that, of course, in the case of all of those inquiries that I just mentioned, except for Yemen, which went through one time by consensus, I think all of them were by votes, and the state itself, certainly in the context of Syria or Myanmar, others, didn't want those inquiries, refused to cooperate. I mean, our good friend Justice Kirby wrote to Kim Jong-un and said, can we come over and investigate? And, didn't get an answer to the letter. That's been a challenge. So obviously these inquiries are involved in situations like the ICC certainly has been involved in sometimes, where the state itself isn't happy about it. But I think fundamentally, you're going to need that effort. They're going to have to try to gather evidence from outside. That's imperfect. But for the victims of those crimes, that'll be very valuable evidence. And at the end of the day, unless there's an international court, it will take a national court somewhere that has a solid basis of jurisdiction. We hope that country itself, after transition, that'll make use of that material. Finally, on the question of the U.S. and ICC, Jennifer and I were on a panel a week ago today at International Law Week at the beginning of the 6th Committee in New York on ICC in the U.S., so we discussed these things at length, and I pointed out the challenges that the United States has ratifying treaties. As famously, I used to talk about how the United States and Somalia were the only two countries that hadn't ratified the Convention on the Protection of the Rights of the Child. And of course, as you probably know, Somalia later did ratify it. And so the United States is alone, but as our friend Nabi Pillay would say, well, you protect the rights of the child a lot better than states that do, some states that have passed it. But it's very, very difficult in our political system to get these treaties 2/3 of the vote in the Senate. It's impossible to get 2/3 for almost anything in the Senate. I remember the really tragic example about 6 years ago. We tried to really put an effort on the Convention on Disabilities, and we needed 67 votes. And Bob Dole, who was permanently disabled in World War II, was even on the floor, a retired senator, trying to get his Republican colleagues to vote for it. And the argument was the Convention Against Disabilities doesn't require the U.S. to do anything that it doesn't do already because our own Disabilities Act is much stronger. In the end, we got 62 votes and needed 67. So it's a very, very difficult thing. And what those of us in the United States that believe in international law is to continue to work and develop a strategy for getting there. But I mean, it's even like as we have in the law of the sea, which every one of our defense secretaries and joint chiefs of staff chairs wants us to ratify it, and we can't get it through the Senate. But our position is that we comply with it. And what we were working on the ICC, at least in the Obama administration, was moving toward a sort of a non-party partnership, and obviously in the work that we did to, when Bosco Ndagana surrendered at our embassy, we made the contacts, we got the Rwandans, we got others, and we got him to The Hague. When Ungwen surrendered to the counter-LRA operation, he surrendered to the U.S., of course negotiated with Uganda and the African Union, who were involved in that operation, but eventually got him to the ICC, even though it involved putting him on a U.S. plane between Obo and Bangui, which is about 800 kilometers, because the UN flight couldn't fly at night. And so we want to get in there and contribute. Of course, people say, well, what are you going to do about yourself? Isn't this a matter of immunizing yourself? And our position in the U.S. has to be that we're going to hold ourselves accountable for all these crimes, just as most of our ICC colleagues believe and do, and never give a reason for anybody to make an argument that the U.S. should be brought to justice at an international court. Obviously, in regard to the Afghanistan case and torture of detainees, I think we didn't fulfill that level of obligation, and I continue to believe that we should through special counsel and through national process. And I recently joined with several of my other former international prosecutors like Carla and Richard Goldstone and Ben Ferenz and I'm trying to remember who else we have, and David Crane in a submission to the ICC on Monday, arguing in favor of the prosecutor's appeal against the decision of the pretrial chamber that wouldn't have allowed our investigation to go forward in the interest of justice. Thank you.
I mean, I actually don't have much to add. I agree with much of what was said with respect to the issues of the mechanisms. The one point that I would make, though, is that I do agree with Chino, that there is a usefulness in thinking about how we can strengthen domestic investigative mechanisms, because those are really important. You're not going to have an institutional mechanism that is able to do a really good job in a conflict situation and so on. So I think it's useful to make sure that you've got people on the ground that understand the situation, that would be able to engage in actual investigation, particularly because for real investigation, you also require access to the territory. So hopefully you have trained and capacitated nationals of that particular situation to be able to engage. Otherwise, where are you going to get the materials from? So I think it's certainly a useful point that Chino has made. On the question of the veto, of course, I mean, absolutely. It is a normative point, though, right? That the veto is not a good thing, and I assume that everybody in this room, myself included, and I'll be very happy for once to be with the majority, is a bad thing. We can all agree to that. But it is in the Charter, right? It is in the Charter, and so it is the law, even if we were to have a declaration that says, you know, the veto ought not to be used. The fact is that it can be used, and that there's very little that we can do. What we can do, though, to address your particular concern is rely a lot more creatively on the Uniting for Peace resolution, but in order to give that some steam, as I said, that would require an amendment of the ICC statute, which could not be vetoed. So that's a way that you can do it, but I'm afraid the veto is a reality for a very, very long time, probably forever.
Well, these were really helpful questions. Thank you. I think we probably need to end promptly at 4, and I was asked to give a couple summary conclusions, drawing things together. So I guess I'll just do that for 1 or 2 minutes. So I think Serge reminded us that we may feel dispirited about pushback in our field, but from 1945 till 1993, or 1946, the end of Nuremberg to the formation of Yugoslav Tribunal, there was almost nothing happening. So now we at least have a lot going on. And I think it's really helpful to go back to the experience of the ICDY and see those arrests didn't just happen. You had the Security Council behind the tribunal, you had major powers conducting arrest operations, and you had the leverage, and I think the US first put on the leverage, conditioning financial assistance to countries in the region, and then the EU. So all this pressure is how you get people to The Hague, and it bears for reflection how much more support could be given to the ICC if there really were the will, because we do know how this actually can work. Steve, I love the optimism of all you've shared with us, what the IIIM is going to be able to do, but also reminding us there are thousands of people being held, and there's some urgency to solving all of this, and conditions of humane detention and releases, and countries who don't want releases, but there's actually some real imperative to getting this solved. Innovative ideas out of our friend Nick in terms of feeding into using the mechanism information to feed into sanctions regimes. DIRE gives us a level of complexity and some warnings: don't raise issues. There can be pushback, and even on the Crimes Against Humanity Treaty, I guess we will see the pushback, and can it remain strong in the face of this? And so I just want to thank you all, and thank you to the audience.